Hello friends, welcome back to Kaydanivato. Today we are diving into the chapter 38 of Bhartiya Nagrik Suraksha Sanhita. This chapter deals with the limitation for taking cognizance of certain offences. This chapter includes section 513 to 519. This chapter guides us how and when court take cognizance of offences and computation of limitations and exclusion of limitation, and how even when court can extend this limitation in some cases. So if you are law student, law practitioner, or curious about the timeline and limitation, then this chapter is going to explain all timelines and limitation for taking cognizance in simple terms. So stay tuned. We are going to break down this chapter section by section and its significance. Section 513, definitions. This section defines the term period of limitation as the duration specified as section 514 within this chapter for taking cognizance of the offences. Section 514, bar to taking cognizance after lapse of period of limitation. Key provisions. General rules. No court shall take cognizance of an offence after the expiry of the period of limitation. Punishment based limitation periods 6 months if the offence is punishable with fine only. 1 year if the offence is punishable with imprisonment for a term not exceeding 1 year. 3 years if the offence is punishable with imprisonment for a term exceeding 1 year but not exceeding 3 years. Determination of limitation period. For offences that may be tried together, the period of limitation shall be determined with the reference to the offence punishable with the more severe punishment. Section 515, commencement of the period of limitation. Key provision. General rules. The period of limitation shall commence on the date of the offence when the commission of the offence was not known to the person aggrieved or to any police officer, the first day on the which such offence comes to the knowledge of such person or to any police officer, whichever is earlier. When it is not known by whom the offence was committed, the first day on which the identify of the offender is known to the person aggrieved or to the police officer making the investigation, whichever is earlier. Exclusion of first day. In computing the period, the day from which such period is to be computed shall be excluded. Section 516, exclusion of the time in certain cases. Key provisions. Time during other prosecutions, the time during which any person has been prosecuting with the due diligence another prosecution with, whether in a court of first instance or in a court of appeal or revision, against the offender shall be excluded. Injunction or order. Whether the institution of the prosecution has been stayed by an injunction or order, the period of the continuation of the injunction or order, the day on which it was issued or made, and the day on which it was withdrawn shall be excluded. Notice or consent required. Where notice of prosecution for an offence has been given, or where the previous consent or sanction of the government or any other authority is required for the institution of one prosecution, the period of such notice or the time required for obtaining such consent or sanction shall be excluded. Explanation. In computing the time required for obtaining the consent or sanction, the date on which the application was made and the date of receipt of the order shall both be excluded. Section 517, exclusion of date on which court is closed. Key provisions. Court closure. Where the period of the limitation expires on a day when the court is closed, the court may take cognizance on the day on which the court reopens. Definition of court closure: a court shall be deemed to be closed of any day if during its normal working hours it remains closed on that day. Section 518 Continuing offence. Key provisions. Fresh limitation period. In the case of the continuing offence, a fresh period of the limitation shall begin to run every moment of the time during which the offence continues. Section 519 Extension of period of limitation in certain cases. Key provisions. Extension of limitation of period notwithstanding anything contained in the foregoing provisions. Any court may take cognizance of an offences after the expiry of the period of limitation if it's satisfied on the fact and in the circumstances of the case that the delay has been properly explained or that it is necessary to do so in the interest of justice. Legal analysis and implications. Ensuring timely prosecution. These provisions aim to ensure that offences are prosecuted within a reasonable time frame, promoting justice and preventing undue delays. Protection against state claims. By imposing limitation periods, the law protects individuals from facing charge for offences that occurred a long time ago where evidence may be scarce or unreliable. Flexibility in exceptional circumstances. Section 519 provides courts with the discretion to extend the limitation period in the exceptional cases, balancing the need for timely justice with the interest of justice. So friend, that wraps up our detailed overview of chapter 38 of the Bhartiya Nagrik Suraksha Sanhita 2003. We learned how the law defines limitation periods, when they start, exclusion, continuing offences, and even court discretion in extending these periods. Understanding these timelines is crucial as they ensure justice is delivered timely and fairly while balancing the rights of individuals. So friends, this was chapter 38 of Bhartiya Nagrik Suraksha Sanhita, explain us limitation for taking cognizance of certain offences. If you found this breakdown useful, then share, like and subscribe this channel. We will meet soon with next chapter in next video. Till then, bye, take care, Jai Hind, stay connected with Kaydanivato.